Procedural due process, often abbreviated as PDP, is a fundamental concept in American constitutional law. It ensures fairness when the government acts against an individual. The constitutional foundation for this protection is split between two key amendments. For actions taken by the federal government, we look to the Fifth Amendment, which states that no person shall be deprived of life, liberty, or property without due process of law. When state or local governments are involved, the requirement is found in the 14th Amendment, which contains an identical due process clause applicable to the states. In essence, procedural due process mandates that before the government can take away someone's life, liberty, or property interest, it must follow fair procedures. These procedures are not fixed. Their required rigor depends on the context, which we will explore throughout this series. For now, understand that PDP is the constitutional shield against arbitrary governmental action affecting fundamental interests. We established that procedural due process protects against arbitrary governmental action. However, the Constitution imposes these requirements only when the government itself is the actor. This brings us to the first critical threshold: state action. If the deprivation of life, liberty, or property is purely the result of private conduct, procedural due process protections do not apply. State action is present in obvious scenarios, such as actions taken directly by police officers or state employees. But the concept extends further. Private actors can sometimes be treated as state actors under two primary theories. First, the public function doctrine, where a private entity performs a function traditionally and exclusively reserved to the state, like running an election or operating a public utility. Second, the significant state involvement test, where the state significantly encourages, authorizes, or becomes entangled with the private conduct. If state action is found, we proceed to analyze the protected interest. If not, the analysis stops here. Now that we have confirmed state action is present, we move to the second crucial step: identifying what interest is being deprived. Procedural due process protects life, liberty, or property. Let us first examine what the Constitution recognizes as a protected property interest. Importantly, this is far broader than just physical possessions or real estate. Property, in the constitutional sense, is not based on subjective desire or mere hope. Instead, the Supreme Court, notably in Goldberg v. Kelly, established that a protected property interest exists only when an individual possesses a legitimate claim of entitlement to the benefit or status. This entitlement must stem from an independent source, such as a statute, an existing contract, or deeply rooted custom or understanding. If the government official retains discretion to deny the benefit, there is no entitlement, and thus, no protected property interest requiring due process safeguards. We are looking for a clear, legally recognized claim. Having established what constitutes a protected property interest, we now turn to the second protected category: liberty. Crucially, constitutional liberty extends far beyond mere physical restraint, such as incarceration or detention. Liberty interests are implicated whenever the government deprives an individual of certain fundamental non-physical rights or statuses. A primary example involves professional licenses. The government cannot arbitrarily deny someone the ability to practice their chosen profession, like medicine or law, without due process. Furthermore, liberty protection covers situations where government action imposes a significant stigma or brand upon an individual that effectively forecloses future employment opportunities. This is often analyzed under the stigma plus test. If the stigma is coupled with the denial of some other tangible right, such as the loss of a job or license, a liberty interest is triggered, demanding procedural safeguards. Now that we have successfully identified a protected interest, whether it is life, liberty, or property, we move to the fundamental procedural requirements mandated by the Due Process Clause. The government cannot deprive you of that interest without two essential components: adequate notice and a meaningful opportunity to be heard. Regarding notice, the requirement is strict. The notification must be reasonably calculated, under all the circumstances, to apprise the interested party of the charges or proposed action against them. It must be sufficient to allow them to prepare a defense. Concerning the hearing itself, it must be meaningful in the context of the deprivation. It cannot be a mere formality. These two elements, proper notice and a meaningful forum, are the baseline. However, the Constitution does not mandate the same hearing in every situation. The crucial next question, which we will address immediately, is determining the precise extent or amount of process that is constitutionally required. We establish that notice and a meaningful hearing are the constitutional flaw. But how much process is enough? The answer is not static. The Supreme Court recognized that requiring a full trial-like hearing before every minor deprivation would cripple government administration. Therefore, the precise amount of process required is determined by a flexible balancing test established in the landmark case, Matthews v. Eldridge. This test, decided in 1976, replaced rigid formulas with a pragmatic approach. Instead of asking if process is due, Matthews asks how much process is due. It requires weighing the private interest being affected against the government's interest in efficiency and cost, using three specific factors. This balancing act ensures that the procedures implemented are tailored to the specific risk of error and the value of the right at stake. Now we dissect the three elements that the court requires us to weigh. First, we assess the private interest that will be affected by the official action. This factor asks how significant the benefit or right is to the individual. Is it essential for survival, like welfare benefits, or is it a less critical entitlement? Second, we examine the risk of an erroneous deprivation under the current procedures. We must evaluate how likely the current process is to make a mistake, and crucially, what value additional or substitute procedural safeguards would add in reducing that risk. For example, would adding an evidentiary hearing significantly improve accuracy? The third and final factor is the government's interest. This includes the government's administrative burden in providing more process, as well as any significant fiscal impact that increased procedures would impose on the public treasury. The final determination of due process hinges on balancing these three competing considerations. The balancing test we just reviewed directly informs the critical question of when the required process must occur. Should the hearing happen before the government action, or can it follow? Generally, the timing hinges on the weight of the private interest identified by the first Matthews factor. When the interest is high stakes, think immediate termination of essential welfare benefits, as seen in Goldberg v. Kelly, the Constitution usually demands pre-deprivation notice and a hearing. The risk of erroneous deprivation pending the hearing is simply too severe to tolerate. However, for less critical interests, or when the deprivation is sudden, random, and negligent, the government may act first. In these scenarios, a prompt post-deprivation remedy, such as a swift administrative review, often satisfies due process requirements. The Matthews analysis thus dictates whether the timeline requires the hearing to precede the government action or follow it closely. Now let us apply this timing analysis to common scenarios frequently tested on the multi-state bar examination. Consider the revocation of a driver's license or a professional certification, such as a medical license. In these situations, the private interest affected is substantial. Losing the ability to drive or practice one's profession severely impacts livelihood and liberty. Because the private interest is high, and the government's administrative burden to provide a brief pre-deprivation hearing is often manageable, courts almost always mandate notice and a hearing before the license is officially revoked. Contrast this with public employment. If a tenured professor faces termination, pre-deprivation process is mandatory. However, for minor disciplinary actions against a public employee, such as a short suspension without pay or a reprimand, the private interest is deemed lower. In these lesser cases, the government may impose the discipline first, provided a prompt and meaningful post-deprivation review is available shortly thereafter. The key is always weighing the severity of the immediate impact against administrative feasibility. We have analyzed the specific timing requirements in various contexts. Now, let us consolidate this into the definitive roadmap for analyzing any procedural due process question on the multi-state bar examination. The analysis always proceeds sequentially. First, confirm the presence of state action. If the government is not involved, the analysis stops immediately. Second, if state action exists, determine whether a protected interest in life, liberty, or property is at stake. If no protected interest is implicated, no process is due. Third, assuming an interest is implicated, we must determine the amount of process required by applying the three-part balancing test established in Matthews versus Eldridge. Finally, the results of the Matthews analysis dictate the specific procedures required, the necessary level of notice and the required scope and timing of the hearing. Mastering this four-step sequence is the key to successfully navigating procedural due process questions.